Again, welcome. The OEC is honored to host this presentation from Fair Shake Environmental Legal Services, exploring the meaning of the Clean Water Act's impairment designation, a total daily maximum load, also called the TMDL, and the benefits and limitations of the designation for Western Lake Erie. As part of this presentation, we'll hear about the Chesapeake Bay TMDL and how that has worked and how that came about. We have scheduled an hour for today's webinar. And as I'm trying to advance the slide, thank you. We have scheduled an hour. You can click on the hand icon next to your name to raise your hand, and you will be unmuted to ask your question, or you can use the question box available on your screen to type your question. We will work to answer each one with the time allotted. But before we begin the main presentation, I'd like to give a little short overview of the OEC for those who may be unfamiliar with our organization. As you can see, our mission is to secure healthy air, land, and water for all who call Ohio home. We are a statewide organization that has been advocating for Ohio's healthy and clean environment for 46 years. While we seek to engage in all of Ohio's environmental priorities, we do focus on some key issues. As you can see, we have a number of programs, including our Clean Water program, where we work to protect and restore many of Ohio's waters by promoting policies to reduce the threats from algae causing pollution plaguing Lake Erie and many of Ohio's inland lakes, such as Grand Lake St. Mary's. With that very short introduction of the OEC, always happy to answer more questions about our organization, but I'd like to get us underway with our main event and introduce Emily Collins. Emily is the Executive Director and Managing Attorney of Fair Shake Environmental Legal Services, a nonprofit law firm in Pittsburgh, Pennsylvania and Akron, Ohio, designed to provide environmental legal services to modest means clients and teach young attorneys how to sustainably serve the same clients with environmental legal needs. Emily received her BA from New York University's Gallatin School in 2001 and her JD from Pace University School of Law in 2004. And with that, I will hand over the presentation to Emily. And again, please raise your hand if you have any questions or use the chat box to type.
All right, thank you. I think I'm unmuted and can advance the slides now. So thanks for the introduction, Adam. I'm really happy to be doing this for everyone. I have taught I don't know how many classes on the Clean Water Act at the University of Pittsburgh School of Law, and it's always nice to talk to folks who are really thinking about these issues in context and outside of the classroom. So I'm thrilled to be able to do this. I was asked to give this webinar to talk about the Clean Water Act process for bringing a waterway, kind of back from the brink. And anytime we're talking about that, we're talking about the standard that many people call the fishable, swimmable standard. And as everyone knows, it's not just fishable and swimmable. We're also looking to be able to drink our water, so fishable, swimmable, and we should think of it as drinkable too. So how do we get there is a process that the Clean Water Act has anticipated and has some distinct terms associated with it that we'll go over. And I was also asked to talk about how voluntary agreements kind of worked in the Chesapeake context. So I'll go over that too and try to bring these two different contexts together within a single process under the Clean Water Act. So that's my agenda for the day, and I admit that I'll have to go pretty fast through all of this because it's kind of detailed, but I'll do my best and try to answer as many questions as possible at the end. So to get started, and Adam, I think I do not have control. There we go. Okay. It's essentially a three-step process, and a lot of times I like to think of it as 4 steps, but let's focus on 3 for now. There are 3 steps in addressing water quality issues under the Clean Water Act. It's a designation process first, Then developing criteria so that we're meeting the designated uses of a particular water body. And third, you have to ask if those criteria are being met or not. And if not, then we have to do something to bring it back and plan to bring it back. And that's done through identification of a water body as impaired, and then developing something called a total maximum daily load. So we'll go over all of those steps in detail. The first step, designating uses, it's kind of like zoning, for those of you who know local government. State government can decide what it wants to use a water body for. And many of you are familiar with that kind of designation process. We want to use this over here for trout fishing. We want to use another water body for irrigation for agriculture. And to do that, we need to make sure that we're meeting certain quality criteria. You'll notice that the purposes of designating uses are very, they're kind of expected. It's to enhance water quality, not to diminish it. So when a government is thinking about what uses it wants for a water body, you'll notice that no one's talking about the use of an industrial sewer, for example. So we're not degrading water body, we're making it better through this designation of uses. And public water supply tends to be one of the uses. You can get very detailed about these uses if you want to, and many states have. For the second step, to develop criteria, the reason for developing criteria is much different than it is in developing uses. It's much more scientifically based instead of political decisions like you would expect in deciding what uses you want. Instead, once the policy choices are made by deciding on a use for a water body, a water quality criteria is developed based on scientific studies. And this is done by pollutant. So just as an example, 250 milligrams per liter of chloride may be the limit for what a certain segment of a river or a stream could contain, and still meet the water supply use. And it's just an example to give you a sense of what a criterion might be. For nutrients, it's really rare to see a numeric criterion. Instead, we usually see narrative criteria, which presents some challenges, but we'll talk about that in a little more detail in a bit. Now, for the third step, called a use impairment, this is an identification process. So you're identifying water ways where the criteria are not being met. And if the criteria are not being met, then the use is impaired, which sounds like a really simple process, but it involves lots and lots of water quality data and checking seasonal variations in the data, that kind of thing. To ultimately decide whether a water body is impaired. And if it is, the answer under the Clean Water Act is pretty simple. You have to create a plan to make sure that the water body achieves its uses. And that plan is called a total maximum daily load. States that don't identify a water body as impaired could be subject to EPA making the decision on their own, or a citizen trying to enforce so that that decision is made. But the standard for doing that is to make sure that it's an appropriate load of a certain pollutant for the type of water body that you're focused on, with a margin of safety. That's what we're looking for when a use is impaired. Perhaps I'll go back for a second. So the use impairment step 3, is often followed by a step 4, which is actual implementation of a total maximum daily load, and that takes a good bit of work in and of itself. So once you come up with a plan, you actually have to implement the plan. I haven't listed that as step 4 here, but just for your knowledge, I wanted to make sure that that's present. All right, now just an example of water quality standards in Ohio and Michigan for nutrients are listed on this slide. And you'll notice that it doesn't have the numeric criteria that I was talking about, except for that 1 milligram per liter of phosphorus for point sources in Michigan. But otherwise, this is something we call a narrative criterion. And it's kind of difficult to tell, right, when exactly you have exceeded that criterion. So that's been a problem across the U.S. for dealing with nutrients. But the same was mostly true for the Chesapeake Bay, which I'll talk about momentarily. And the Chesapeake has a recent TMDL to address its impairment. And the TMDL for the Chesapeake is based on dissolved oxygen and a chlorophyll criteria, not nutrient criteria, at least not in full. So it's interesting to think about how you can develop a plan for bringing a water body into use attainment based on nutrient criteria, especially when considering what they've done in the Chesapeake. And there are some great scientific articles out there talking about the method that was used in the Chesapeake to come up with their water quality standards. All right, and let's just talk for a moment while we're looking at this slide about the implications of impairment. Once a water body is identified as impaired, and you're thinking about a TMDL, I'll just name 2 of the implications from a legal perspective. One of them is that new contributors to a water body, so new people who will be loading pollutants that could affect the water body, could be restricted from developing in the way that they ordinarily would. So a new development can't cause or contribute to an impairment. So their permit could be very, very restrictive, and that's always a consideration because we don't want to necessarily restrict new development. So bringing a water body into use attainment is really important. Also, point sources and non-point sources, so sources with pipes and non-point sources that have kind of a dispersed flow, they could be asked to scale back their contributions if we have a TMDL at issue. So the Clean Water Act does address non-point sources within the TMDL framework, or it has the potential to, which is not something we think about when we're talking about a water body that's unimpaired. So those are some pretty significant repercussions of impairment. So with that, let's talk a little bit about the Chesapeake. And I'm doing this not to be completely, comparative to Lake Erie, but there are some interesting correlations. The Chesapeake Bay is a multi-jurisdictional sink, right? So there are 6 states that contribute to the Bay and DC. It's a huge contribution area. Just like Lake Erie, it's worth a good bit of money in our economy, and it's kind of a treasure. So the Bay is something of importance, as are the Great Lakes. So some similarities. Also similar to Lake Erie, there have been several agreements, and you can almost think of these agreements as amendments to the original agreement. But in 1983, we saw the first agreement to clean up the Chesapeake Bay. And it was literally just 1 page long. 2 if we increase the font, that kind of thing. So it was an agreement really just to work together to address the bay's decline of living resources. And a lot of times when you hear people talk about the bay, they're thinking about the aquatic resources that the bay provide. It was signed by 4 states, or I should say 3 states and DC, and the federal government. And in that agreement, there was recognition that the bay was already in poor condition. It was amended, the 1983 agreement was amended in 1987 that included a reduction target, so a numeric requirement that was 40%. They wanted to see a 40% reduction of nitrogen and phosphorus entering the bay by the year 2000. That date came and went, so we didn't necessarily see it being successful. And a lot of people questioned the approach. Of course, there was a lot of question about political will as well. Interestingly, in 1999, we saw some litigation. I'm going to talk about this litigation again in a slide in a moment. But this litigation, hearkening back to what we just discussed about how you get to a TMDL, was all about Virginia's failure to submit both the identification of an impairment and a subsequent TMDL. Ended in settlement, and we'll talk about that in a moment. In 2000, we saw yet another agreement related to the Chesapeake. There are also some amendments to the Clean Water Act to establish some programs to coordinate activities among the states. But in 2000, something called the Chesapeake 2000 agreement was signed, and it had over 100 goals related to species protection and water quality attached to it. Same signatories as the 1983 agreement. And within the time that these agreements were being entered into and implemented, the bay's quality declined. So we didn't see a lot of benefit, although there was some progress made under both of those agreements. The bay's water quality declined. Sorry to take you through a history lesson at 3 o'clock, but just a little bit more on this before we get into the nitty-gritty. There was another submission to Congress to start thinking about the current status of the bay in 2008. And then in 2009, we saw an executive order from President Obama that set into stone kind of this federal leadership committee to address things going on with the bay. So it wasn't just the 4 signatories and the federal government at the table talking about things. It was kind of more of a leadership position with the federal government to control pollution from all sources. And very quickly after that executive order came out, we saw EPA announcing their intent to come up with a basin-wide TMDL. So all states, all contributing states would be subject to it. It's the first of its kind that we've seen, and they acted extremely quickly on it. For those of you who know how these environmental processes go, getting an executive order in 2009 and even saying that you intend to create a basin-wide TMDL within the same year is pretty miraculous. But shortly after that, we got a draft TMDL for public comment, and by the end of 2010, a final TMDL set in stone, which has been the subject of quite a bit of litigation. And it's been upheld by the federal appellate court at this point. We'll see if the Supreme Court takes up the case, but that's kind of where we are with the current Chesapeake Bay TMDL. So that's pretty fast, but it's fast considering everything that happened beforehand. So it didn't come out of nowhere. There was a great deal of scientific study done on the bay, in part because of the 1983 agreement and subsequent agreements. So it certainly didn't come out of nowhere. In fact, and let's move to the next slide, there's a line of cases dealing with TMDLs among the different federal circuits, and they're kind of the same ilk. And the one that a lot of people point to is establishing this mandatory duty on behalf of the U.S. EPA to come up with a TMDL in the face of states not doing it is Scott versus City of Hammond. It's from the 7th Circuit, and in that case, the court gave us this idea that when a state fails to submit a TMDL and fails to identify an impaired water body that leads to the failure to submit a TMDL, the U.S. EPA should consider it a constructive submission that no TMDL, total maximum daily load, was needed. It's really important. So if we have a constructive submission that no TMDL was needed, then we have something that the U.S. EPA can actually make a decision on. And that gives the U.S. EPA the ability to do it themselves pursuant to the Clean Water Act. So that's essentially the kind of thing that the U.S. EPA was relying on when it came up with the Chesapeake TMDL. And this is in part just to show you how this progressed over time. I had mentioned earlier this American Canoe case. It's a case that settled, but was based on the same theory as Scott versus City of Hammond. And EPA agreed, based on the American Canoe litigation, that Virginia's failure to submit a TMDL meant that they needed to step in. And EPA agreed to a timeline to develop a TMDL for the Chesapeake Bay back in 1999. It was exclusive to Virginia at that time, but that in and of itself kind of set things in motion. And some people will tell you, some people who've been involved in this for a long time will tell you that they thought that was really kind of a tipping point in progress on the Bay. So the 2010 TMDL that ultimately did come out may be thought of as at least 11 years in the making. So it's important to reflect back on that. All right. Let me talk just a little bit about what this Chesapeake TMDL looks like, because it's kind of hard to envision when you have multiple jurisdictions contributing what a cap could look like. So there are various levels of this that you should think about. For the Chesapeake TMDL, there are 3 different pollutants at issue, and I think I told you earlier, the reductions essentially come from a water quality criteria that involve dissolved oxygen. So interesting to think about how that translates. But they came up with these reductions based on a great deal of scientific data and modeling. So for the entire basin, they want to see a 25% reduction in nitrogen, which means there's an allowed loading of 185.9 million pounds of nitrogen into the basin. Same kind of thing with phosphorus, and then sediment is the 3rd pollutant at issue in the Chesapeake TMDL. And for the timeline, they're thinking about a 60% pollution, 60% of the pollution controls should be in place by 2017, which is pretty quick. So we should see some progress very, very shortly. 100% of pollution controls should be in place by 2025. And even when 2025 rolls around, assuming that timeline is something that happens as expected, this Federal Leadership Committee has told us they expect some lag time between the pollution controls being in place and a healthy bay, and they expect that lag time to be between 20 and 40 years, which is an incredible amount of time. My understanding of their reason for thinking that is that the groundwater has been, contaminated enough that nutrients will continue to seep into the bay from the ground for some time. So, getting started early should make a big difference here. Now, EPA has no ability under the Clean Water Act to actually implement these TMDLs. In fact, it's pretty explicit that it's left out of their authority. So the US EPA can come up with these limitations pursuant to the Scott versus Hammond framework, but states are left to actually implement. What the federal government is doing with the Chesapeake TMDL is making sure that they have something that they're calling reasonable assurances from states, that the pollutant loads that they were handed would be achieved and maintained. So they do have some oversight authority, but they can't actually implement. And I would argue that they do have some authority to, for example, certainly comment on, but also restrict point source permits as they're coming through the pipe for renewal or something like that, if they think that it's not reducing the load that states were requiring to be reduced pursuant to their watershed implementation plans. But I fully expect that EPA will be leaning on states to use their plans, their watershed implementation plans, to continue to give them those reasonable assurances over time. And I mentioned earlier that it's through the TMDL process that we see non-point sources being addressed, and this is pretty explicit in the Clean Water Act that non-point sources are to be included in TMDLs through something called a load allocation. And the way the EPA modeled that for the purpose of coming up with the percentage reductions, and they came up with percentage reductions not just basin-wide but also by state. The way they did that for non-point sources was to use a model that they called Scenario Builder, and I gave you some categories of the things that they modeled here on this slide. So of course, because we're talking about a tidal estuary, there are some things that perhaps we wouldn't be considering for the Great Lakes, but many things there we would be considering as non-point sources for Lake Erie. And it's interesting, atmospheric deposition is even one of them. So that's something that can be modeled and scientifically modeled, and that's what EPA did here. The Scenario Builder was specifically attacked in the litigation over the Chesapeake Bay TMDL, and the court didn't find any problem with EPA's use of it. So something to be mindful of, and just to give you some sense of comfort about this model, we model almost for every kind of environmental permit that we issue. So in the air context, we're continuously modeling what we expect to happen, not necessarily what actually happens, and we base permits off of that. So it's a pretty tried and true method. Scenario Builder itself is fairly new. It's a fairly new model and likely can be improved upon, but that's how they came up with their numbers for the Chesapeake TMDL for non-point sources. I hear this question all the time. So isn't Lake Erie different because we have an international jurisdiction contributing to the sink? And it is different, but the Clean Water Act doesn't necessarily take account of or care about that. So the Clean Water Act certainly doesn't reach Canada. We can't impose it on them. But we can carve any contribution from something that we don't have control of. We can carve that out of a TMDL that would apply to U.S. jurisdictions. So we should be able to mathematically deduce, what should apply to one jurisdiction versus the other. Of course, I think we would expect to have some kind of negotiation with Canada to make sure that they are reducing their contribution as well, but it's not something that the Clean Water Act itself could handle. I also hear often this question about whether we can handle, whether we can just impose TMDLs on tributaries instead of the actual lake. And the Clean Water Act is pretty clear about this, and we've been pretty clear in all of our regulatory work for different kinds of water bodies. Anytime you're thinking about a particular water body, and this can be between a stream and a river or a river and a lake, but I'm sure you can imagine that the load that a water body can take is different depending on its character. So its flow, its depth, all kinds of things, even seasonal issues, could change each type of water body. So they really do need to be thought of separately. So the Chesapeake did this very thing. So they addressed both local waters, is how it's usually referred to, and the bay. And the reason for doing that is that how much the bay can take, and it is very large sink, but how much it can take is very different than what a single stream could take in terms of load of a pollutant. And just to bring that point home, you can imagine if you're pouring, some kind of chloride into a glass of water. So a lot of us go running and need a little bit of Gatorade. So pouring a little bit of salt or some other kind of something to keep us hydrated into a small glass is going to be much different than a very large glass. And if that, if we're talking about something that's flowing, if it's a stream, right, what you put in is going to be much different than what you would put into a sink. So things to think about, and it has to do with scientific characterizations more than anything else. But if one is impaired, then if one water body is impaired and another is not, obviously we don't need a TMDL for the one that's not. But anytime there's an impairment, what the Clean Water Act tells us is that you do need a total maximum daily load to bring it back into compliance. What happens if there's no TMDL? Then you end up with Scott versus City of Hammond all over again. But also, just from a practical standpoint, without a TMDL, we really don't have the same kind of participation opportunities or enforcement mechanisms. So things do change a bit, and the anticipated scheme under the Clean Water Act just isn't available if we don't capitalize on our opportunities to use the Clean Water Act's tools to bring a water body back into compliance. So that's pretty much it. And the way we can think about TMDLs and impairment often is talked about as a diet. I have been a proponent of talking about it as a budget. So the budget for the Chesapeake Bay is now in place through the TMDL, and budgeting is something that we look for anytime we're engaging on in a new project. So it's just another way to think about it, and I hope that the experience in the Chesapeake is something that we can learn from here in the Great Lakes region.
All right, well, thank you very much, Emily. I know that that was a lot of information for folks, some of it kind of mired in technical jargon, so I'm happy to take questions at this time. Please use the hand icon to raise your hand to indicate you have a question, or use the chat box, question box, to type in your question, and we will read that off for Emily and take those now. And while we're waiting for questions, I guess I'll take the moderator's prerogative and ask, Emily, you had indicated that even if there is a TMDL that is developed, that it's up to the state to actually implement it, and that they have to essentially show a good faith effort to do that. Now, in Ohio and Michigan and Ontario, there is an agreement in place to reach a 40% reduction of phosphorus entering Western Lake Erie and develop a plan to meet that goal. Would that qualify as a legitimate, good faith effort to meet a TMDL were one in place?
It's certainly possible that it could qualify. I think it would depend on what reductions the TMDL itself came up with. So it may be the case that the scientific basis for a TMDL would be a bit different than what was used to come up with the 40% reductions. And you know, I have no reason for questioning the 40% other than to say that you know, there were early agreements in the Chesapeake that dealt with that exact same number, and I think that's what you would want to look at. So a watershed implementation plan would need to ensure it's meeting the reductions that were scientifically, you know, derived from the TMDL process itself.
So essentially, if those plans didn't suss out the different sources and assign reductions to those sources, it's kind of not the same thing, like apples and oranges.
Yeah, I think that's right. And when you say sources, so sometimes these can just be categorical sources at the TMDL stage, and then through the watershed implementation plan, states would be responsible for coming up with, you know, particular targets.
Okay. Well, we do have a question from Tom Jackson. I will go ahead and unmute your line and go ahead and ask a question, Tom.
Okay, I've actually just sent it as a written question. Can you see that?
Let me take a look for you. We do, and I will go ahead and mute your line, and we'll go ahead and ask that question. So let me. The question is, how is developing a TMDL different than the current efforts under the Great Lakes Water Quality Agreement? Isn't a TMDL essentially a redundant effort?
So that's a good question. I couldn't give you kind of a line-by-line comparison, and you know, that's certainly something that you would want to do. But I can say that the ultimate result is going to be different for people who want to be involved in the process. So both citizen enforcement possibilities as well as industry and state enforcement opportunities would be changed if you're using an agreement outside of the Clean Water Act to achieve what you think would be the results of a TMDL process. So that might be one thing to think about, and I think that's a really important thing to think about. So making sure that people can utilize traditional Clean Water Act procedures to ensure their rights, whether they're industry or citizenry or municipalities for that matter, could be a very important part of the process.
Okay, and actually that question came from Laura Johnson. Sorry about that, Tom. I did find your question and have it here. You ask or state that the U.S. EPA Chicago office says in 2014 it approved Ohio's designation of Lake Erie as impaired for drinking water. And how is that different from the impaired designation environmental groups such as the OEC are now seeking? And honestly, Tom, I was not aware that they designated the open waters. I don't think they have as impaired where the drinking water intake is located. They did approve a TMDL or impaired designation and the development of the TMDL for the nearshore waters. And if you think about Western Lake Erie, they essentially broke it up into different segments. And where there are drinking water intakes within those nearshore segments, there is an impairment designation and there is a TMDL supposedly being developed. We have no reason to think otherwise, but the Toledo's water intake is further out from that nearshore segment, and Emily, you can certainly correct me if I'm wrong on that.
No, I think that's right, and there is a 2016 listing that's coming up that the public can be very much involved in. So I think everyone should be very interested in seeing, what the next list of, we call it the 303D list, what it includes, if it includes just the shoreline or the open waters.
Okay. I do see a hand raised from Joe DePinto. I'll go ahead and unmute your line. Joe, you can go ahead and ask your question. I see you also typed it, but I'll give you the chance to ask.
Yeah, actually, my question was already asked initially. The question is, but I might have a little bit more information regarding the Great Lakes Water Quality Agreement process for Lake Erie. I was part of the Annex 4 subcommittee that established tributary by tributary target phosphorus loads in order to achieve eutrophication endpoints in the lake, including harmful algal blooms, Central Basin hypoxia, and Eastern Basin cladophora problems. And I think that process was about as scientifically valid an approach as you could take to revising the target loads for the lake of phosphorus, and also to allocate it among priority tributaries and between U.S. and Canada. And it seems to me that at least as far, maybe not legally, but at least as far as scientific approach, it's as good a TMDL as you're going to get for the lake, and it's been accepted by both Environment Canada and EPA, the parties to the Great Lakes Water Quality Agreement, and they've begun looking at how to implement those target loads for each of the priority tributaries that have been identified, and how to work up into the watersheds of those tributaries in order to achieve those loads. And so I understand that there's a difference between the legal aspects of a TMDL and the more or less the agreement, the Great Lakes Water Quality Agreement, between the countries, and the role that IJC plays in that. But I just don't think that it's worth spending more resources to do the work necessary for a TMDL for Lake Ontario or Lake Erie. Lake Ontario's next, by the way. When we've really already done it, you know, maybe the thing that you want to do is have individual tributary TMDLs to understand how to allocate the load that tributary has been given as far as its share to the TMDL for the whole lake. But I guess I'd like to hear why you really think that we need both processes.
All right, I appreciate that question, Joe, and commentary there. And you know, for the OEC's part, you know, the reason we convene this webinar is really to have a discussion about what TMDL and impairment designation would mean for Lake Erie. Certainly, we are an avid, you know, we're in support of that, but by no means is that to discount the efforts of Annex 4 or the Great Lakes Water Quality Agreement, which we are also in support of. We don't look at those as mutually exclusive, and I think the need really comes from the desire for those domestic action plans to do what we've been asking for all along, which is really identify the sources, the contributors of the phosphorus that's coming into the lake, and really devise a plan that's going to reduce those sources appropriately. Certainly a TMDL and impairment designation is going to offer some legal tools to ensure that the lake's water quality recovers. And for some people, you know, it may come down to a trust issue in hoping that the domestic action plans are going to work effectively, but if there's not, there is some recourse there. And I'm not going to speak for everybody in the environmental community on that regard. I'm just stating one point of view here, but we certainly do want to recognize the good work of Annex 4 and the task team and the legitimacy of the Great Lakes Water Quality Agreement. Emily, I don't know if you have any more to add to that.
The only thing I'll add is that it's really encouraging that you feel like the science is already there and as good as it's going to get, because that's exactly what you need to have a good, you know, enforceable TMDL that then trickles down to individual states to implement. So, and that's kind of what we saw in essence in the Chesapeake as well.
All right, I do have one more hand raised from Dave Ulrich, but please hold your question. I want to get to one that came through on the question box. Michael Murray asks, have there been any innovative approaches to achieve non-point source reductions, in particular agriculture, in the Chesapeake through the TMDL?
That's a great question. So I don't know if I would say innovative, and it'd be nice to probably have somebody who's a little more on the ground to answer a question like that. But I will say that there have been you know, some difficult conversations between the states subject to the Chesapeake Bay TMDL about how to implement specifically with their agricultural sources. And I think those are very, very difficult discussions to have, but necessary ones. And we have seen some progress in Pennsylvania on that front. And I expect we'll see a little more and can speak more to innovation in the near future. But I can't say that I feel like the most capable person of answering that question, but I think that'd be a great second follow-up webinar, OEC.
Understood. Well, and on that point, you know, preliminarily there are groups and teams of modelers that are exploring what best management practice or combination of practices can be effective in achieving that 40% reduction. At the same time, there is ongoing research, edge of field studies that are looking at actual practices and measuring how effective they are in reducing edge of field loss of nutrients, particularly phosphorus. A combination of modeling and direct monitoring is going to inform what those practices are that work best. Getting those practices applied across an entire basin is an entirely different discussion. And I think it's one that really speaks to the need to have some direction, some requirement to have best management practices in place throughout the basin, and really not rely wholly on incentive programs. That is a position of the OEC, of course, but we'd be happy to continue that conversation. At this point, I will go ahead and unmute Dave. Your line is open if you'd like to ask your question. David Ulmer.
Great, thanks very much. I'm with the Great Lakes and St. Lawrence Cities Initiative. First, thank you very much for doing this. I think it's exceedingly important to give very serious consideration to this impaired designation and cranking up the wheels of total maximum daily load in this situation. It's going to be a little bit of a comment, but I'll try to get right to the heart of my question. And this builds a little bit on the last comment / question about having the Great Lakes Water Quality Agreement in place, which has really launched a very, very major effort in terms of doing all of the science, if you will, to figure out the reductions that are needed and where they need to come from, and moving ahead with the domestic action plans and strategies. My real question is, I have a concern about the amount of litigation that TMDLs have generated in the past. And I guess it comes down to a question of tactics and strategy. I think we all want to get to the reductions as soon as we can, regardless of how we get there. And I guess, Emily, I'd be interested in your assessment of the amount of litigation that might be generated by launching the impairment designation and TMDLs, because as I understand it, there's been a fair amount of that with regard to Chesapeake Bay and the Everglades, and where we have a formal international agreement in place, if we might not be better off just relying on that than, the specific Clean Water Act process, which of course won't apply in Canada anyways, because half the lakes are there except for Lake Michigan. So a little bit on what's going to get us to where we need to be the fastest.
Yeah, that's a very good question. So one thing that I should say is that if there is not an impairment designation, we've seen litigation, right? So the risk of litigation, I think, is pretty much equal, whether you have an impairment designated or you don't. And that's been the experience in the Chesapeake. So if you don't have the impairment designation, there are many opportunities for folks to step in and say, through litigation, you should have one. And I think the threat of that kind of litigation is that the folks at the negotiating table are limited to the parties, right, in the litigation, instead of many, many stakeholders. And that might be one of the more important reasons to think about developing a TMDL prior to litigation like that occurring. So, and that's the case that I was talking about, American Canoe in the Chesapeake. That was the kind of case that you might expect when you have an non-designation in other scenarios. So now, if you do have an impairment listing, one way or the other, then you may indeed end up with litigation. And the litigation that's happening in the Chesapeake right now has to do with whether EPA has the authority do what they did. So to enact these fairly restrictive reductions. And as I had mentioned before, so far the courts are saying that EPA did have the authority to do that, and it's important to remember that no one is saying that EPA has authority to implement. So it's true that there is a heightened risk of litigation when you have an impairment listing and come up with a TMDL, but I don't know that I could say that it's riskier than not having one. So how do you get there the fastest? If the science is there, I don't know that, and I'm not in the best position to opine on this, but I don't know that that science couldn't be useful for both things, for implementing the international agreement and having something enforceable just in the U.S. waters. So it's hard to say what the answer to that is, but I would think that avoiding litigation in both scenarios would be preferable, right? And to do that, I think it's quite the stakeholder process for both federal and state governments.
Well, I do appreciate that question, David, and litigation is certainly a concern. I think that everybody has. No one wants to see the Clean Water Act challenged in such a way, and nobody wants to feel like they were forced to the table and agree to something that perhaps they wouldn't have to begin with. I will say that, Emily, please speak to this. The amount of case law out there that sides against states and the federal agency when there is an implementation plan in place and there is progress being shown to reduce agricultural sources, it isn't that strong as far as challenging a TMDL or an implementation plan. Is that right, Emily?
I think that's fair. We're even seeing in Washington State some waste-based litigation dealing with nutrients. So I think that's all to say, without a plan in place that's being well implemented, people are going to look to litigation without the plan in place. So yeah, I think that's fair, Adam.
And for the OEC's part, the main reason that we're in support of the designation is the impairment designation and the TMDL is to have a multi-state effort and to have an implementation plan based on reducing the specific contributing sources that have been, in essence, quantified to the best degree possible with the best available science. With the modeling out there, with the edge of field monitoring results coming out, I think the science is evolving and can inform better those sources and the identification. We have seen just recently with Michigan's implementation plan on the state level outside of the Great Lakes Water Quality Agreement, a lack of that identification. And so a TMDL is a way to get at that. We have another question here. We're getting to the top of the hour, but I did want to fit it in from Tom Jackson. Again, he asks, how many states would have a TMDL goal set for them if the waters of Lake Erie were declared impaired? And to answer that, it would be Ohio, Indiana, and Michigan for the Western Lake Erie. Please correct me if I'm wrong on that, Emily.
I think that's right.
Great. So not seeing any other questions or hands raised, I do want to thank everybody for attending today's webinar. We're very pleased to have Emily Collins join us and give us this presentation and have a very good discussion that is necessary. We'll continue to explore this topic, of course, and look forward to seeing the domestic action plans being developed by the Annex 4 team, as well as the Ohio state implementation plan to achieve that 40% reduction, and what Ontario comes up with for its commitment to also reduce phosphorus entering the lake by 40%. So again, thanks to everybody. You will receive an email when the webinar is available online. Thanks and have a good day.